Hello and welcome. I'm Amritanshu and you're watching Law of the Land on Sabha TV. Today we bring to you two judgments of the Supreme Court on the Bhopal gas tragedy. One directing compensation for the victims and the other directing cleaning of hazardous waste. To discuss the issue, I have with me Dr. Meera Shiva, Coordinator, Initiative for Health and Equity in Society; Avi Singh, Advocate, Bhopal Victims Organization; and ND Jaiprakash, Bhopal Gas Pirit Sangharsh Sahyog Samiti. Now for the headlines. The Supreme Court directs the centre to dispose toxic wastes within 6 months. The court had in 1989 directed Union Carbide to pay compensation of 750 crore rupees to the Bhopal gas victims. And in the same order, the Apex Court had quashed all civil and criminal proceedings against Union Carbide. The Supreme Court on the Bhopal gas tragedy in a recent order has directed the government to dispose all toxic wastes within 6 months. The court has also directed transfer of all pending environment-related cases to relating to the tragedy to the National Green Tribunal.
It's been nearly 28 years since the Bhopal gas tragedy happened, but the hazardous waste is yet to be disposed. According to an estimate, there are 27,000 metric tons of hazardous waste and contaminated soil lying near the Union Carbide plant in Bhopal. The soil and water up to an area of 3.5 km and a 30-meter depth is assessed to be contaminated. The problem has been technically challenging as the contaminated areas lies within densely populated areas. Seized of the matter since the beginning, the Apex Court said that it is well known that toxic materials are still lying around the Union Carbide factory. Its very existence is hazardous to health and needs to be disposed at the earliest and in a scientific manner.
Some studies come out and the studies found that, some research found that the residual of that methyl isocyanates are still present in that soil and water, which is impacting to the human health.
Let's look at what the Supreme Court has directed in its judgment. It has directed single window adjudication of all pending environmental cases by directing transfer of such cases to the National Green Tribunal (NGT). The court has directed that all cases of the Bhopal disaster will now be handled by the Madhya Pradesh High Court. The Apex Court has ordered the High Court to ensure proper functioning of the committees and hospitals set up for Bhopal gas victims. The court has also dissolved the Bhopal Memorial Hospital Trust. Now the management of the hospital will be taken care of by the Ministry of Health and Family Welfare at the centre.
The court said, given the nature of the Bhopal disaster and the fact that it has already reached an advanced stage, this particular case will not go before the tribunal. But all other cases, there will be a system of transfer automatically to the National Green Tribunal.
The Supreme Court has been seized of the matter since 1998 when a petition was filed by the Bhopal Gas Pirit Mahila Udyog Sangathan to protect their rights. The petition began by an appeal to ensure free medicines and basic medical facilities for the affected in Bhopal. People of Bhopal are still suffering. The first generation suffered from the Bhopal gas leak disaster, and the second generation is suffering from the poison that is seeping deep into the underground water from the factory site. Recently, the Supreme Court established a monitoring committee for drinking water. But will this ensure safe drinking water for the people of Bhopal is the main concern. With camera person D.K. Pandey, Subina Roy, Rajya Sabha TV.
This judgment was passed by a 3-judge bench comprising of Chief Justice S.H. Kapadia, Justice Swatantra Kumar and Justice A.K. Patnaik. Ma'am, straight away to you. On the hazardous waste that is there, do we have a technology in India to actually tackle a situation like this, a disaster, a man-made disaster like this?
Actually, we've allowed it to go for so long that it's become more messy. Had it been tackled earlier, something could have been done.
Avi, do you think the way the things are as of now, do you think it actually being taken care of in the near future?
You know, one must be optimistic, but it's very hard given the history. But I must quickly put things in context. We are dealing with two specific problems. In 1984, there was a gas explosion. It was a criminal act, but there was a gas explosion, the gas went in the air, and there was a community affected. Before that, there was waste being dumped in the ground. Those are two acts by the same players, but two different and distinct acts. So all the issues about what went in the ground was not closed in 89. It was only compensation for what went up in the air. Now what went in the ground, it has been recorded throughout after 84, that what has been there and the extent of it keeps expanding. Right now the estimates are at least 10 to 15,000 metric tons of contaminated soil around the site, in addition to the 350 metric tons being stored in the factory site itself. This litigation has been pending in the Supreme Court, but also in another bench in the Honorable Supreme Court, headed by Justice Singhvi, in which an SLP was brought by the Union of India against an order of the Madhya Pradesh High Court. But it must be important that our state institutions, in particular the Central Pollution Control Board, which is a nodal agency under the Environmental Protection Act,
Doesn't have the technology.
Does not have the technology, does not have the will, has not demonstrated the ability to pick up the will or to learn anything.
I'll get in, Mr. Jayaprakash. See, two things. Compensation for the new generation doesn't exist. Okay? Medical treatment now has to be handled by the Madhya Pradesh High Court. And the trust, memorial trust that was on, will now handled by the Ministry of Health at the center. Given this aspect, where do you see the existing situation as far as the waste disposal is concerned, hazardous waste disposal is concerned?
Let me just point out first that there's been no proper assessment of the extent of damage.
Right.
So this question of solving the problem within 6 months just does not arise.
Right.
Because what we've been demanding right from the beginning is that there must be proper assessment of the extent of damage. See? So the German company GTZ, which is an organization set up by the German government, is willing to undertake a proper study. And I think that there must be the government of India and the government of Madhya Pradesh must...
It's been 28 years. How long do you think the process will continue?
Before taking care of this, I mean, you must know the size of the problem.
Right.
It's not just 350 metric tons which is lying. There's a lot of toxic waste has seeped into the ground. It has affected the water, underground water, so and soil. So we must assess the extent of damage. See, one thing is to remove the toxic waste from the ground above.
On the second part, in absence of a compensation, what happens to the new generation victims?
No, not only that, this settlement, I mean, this present judgment, the environmental aspect is only one. See, the first and foremost is restarting of medical research, which ICMR has stopped in 1994. See? And secondly, till today, there's been no proper system of issuance of health booklets to gas victims. Today, a victim does not know to what extent he or she is suffering from, because there is no medical records to prove the extent of damage. For the first time, the Supreme Court has directed, earlier there has been direction which the government has not complied with, to ensure that each gas victim is provided with a health booklet which records the complete medical history of a gas victim. See? Because he or she could prove before a court the extent of damage.
The impact.
And the compensation has to be related to the extent of damage which a victim is suffering from. As of today, the government says only 4,000 victims are suffering from serious damage, which is rubbish, because ICMR's own estimate has shown that at least about 2 lakh victims, are suffering from serious damage. I mean, could, because
of the extent of
yeah, because 36 wards of Bhopal, comprising about more than 5 lakh population, is out of which this ICMR had estimated that at least 2 lakhs are seriously affected. So how is it that after 28 years you are claiming that only 4,000 people are seriously affected?
On that note, it's time for us to head into a break. When we come back, we will talk about the 1989 judgment of the Supreme Court granting compensation. Welcome back. Let's take a look at all that has happened relating to the fight for rights of the Bhopal gas victims. It took the victims nearly 5 years from the year of disaster to get relief after the intervention of the Supreme Court in 1989. The court directed an interim compensation of about 750 crore rupees to provide immediate relief to the victims. But at the same time, it quashed all civil and criminal proceedings against the Union Carbide Corporation.
The Bhopal gas tragedy occurred in the wee hours of 2nd December 1984 when a lethal gas named methyl isocyanide leaked from a pesticide plant called Union Carbide India Limited. The government of the day provided whatever relief they could to the victims, but the main battle began in the courts. Several petitions were filed in the United States and in India demanding immediate relief. It was the Supreme Court which arrived at a settlement.
Not giving of sodium thiosulfate when the medical directors telex it so. And you know, when the autopsies were done, the lungs were bright red, the blood was bright red. That means oxyhemoglobin, no, because of the oxygen, you know, combining with the hemoglobin of the red cells. It was because accepting that meant accepting cyanide poisoning, and it would have affected the compensation.
Let's look at the important parts of the judgment in the case of Union Carbide Corporation versus Union of India and others. According to the judgment, the Union Carbide Corporation had to pay a compensation of about 750 crore rupees for the benefit of the victims of the disaster. The court also disposed of all civil and criminal proceedings against the Union Carbide Corporation and its subsidiaries. It included all cases filed by citizens, public and private entities related to the tragedy. It exempted the directors, officers, employees, agents and representatives related to the disaster. It also dismissed all the cases pending under the Bhopal gas leak disaster registration and processing of claims scheme 1985.
It has been a human disaster, it's an ecological disaster, and despite the passage of so many years, you see, at the ground level, not much has happened.
The implementation of the Apex Court Order of Distribution of Compensation began in 1992. According to the information available with the Ministry of Chemicals and Fertilizers, over 1500 crore rupees have been distributed as compensation to over 5 lakh claimants. Warren Anderson, the former CEO of Union Carbide, has been charged with culpable homicide. But the Indian court has not been able to bring him into India. This is because the US court has rejected India's request plea, saying that it does not meet the certain provisions of the bilateral extradition treaty between US and India. With camera person D.K. Pandey, Subina Roy, Rajya Sabha TV.
As per the figures mentioned in one of the following judgments by the same bench, the court mentioned that a total number of 2,660 persons suffered agonizing death and between 30 to 40,000 persons sustained serious injuries as a result of the disaster. My question to you, Mr. Jayaprakash, straight away on the issue of compensation. One part immediately has been settled, which was the initial impact, largely. What happens to the next generation of victims? Do we have a mechanism to provide support as far as ecology is concerned, as far as hospitals are concerned, as far as compensation is concerned?
See, as per the 89 judgment, only 3,000 people had died and 1,02,000 people were injured. This we had, that Bhopal Gas Pidit Mahila Udyog Sangathan, Bhopal Gas Pidit Sangharsh Sahayog Samiti had challenged this settlement. And in 1991, the court upheld the settlement figures, saying that we have not been able to provide additional figures to show that the magnitude was greater. But at the same time, the process of disbursement of compensation, categories, claims codes started functioning in 1992. And as per the records of the claim codes, compensation has been granted to 5,74,000 gas victims. You see? Which is more than 5 times the number of gas victims as per the settlement. Because settlement said only 1,05,000. It was more than 5. So in 2004, we again filed a petition before the court showing that the figures on which the settlement was based was absolutely ridiculous. You know? And that the court must go through the present figures of 5,74,000 and increase compensation accordingly. And subsequently, on 3rd December 2010, the government of India has come forward to challenge the settlement of 1989. And now the court, the government claims that more than 5,000 people have been killed, and they have accepted the figure of 5,74,000 as the number of victims who had suffered injuries.
So we are still grappling with the earlier litigation, and there is no resolution of most of the three issues, that is compensation, health and ecology. So there is no
no, I would like to add here, see here even in the curative petition, the figures provided by the government underestimates the number of seriously affected victims, you know.
And that is where the fight is.
Yes, we have said that there must be, we said we have, please examine the present health condition of the gas victims. And on what basis have you come to the conclusion that only 4,000 people have been seriously injured? That is why we said that each gas victim should be provided a health booklet with complete medical history of the gas victim to show that all those who are suffering and going to hospitals today should be declared as permanently affected. And compensation should be increased accordingly.
I'll get in Mr. Avi Singh. See, on the point of first, the criminal aspect of the entire case, because initially 1989 criminal and civil both were barred by the Supreme Court, but there's been a change in that. First. Second, also on the aspect of compensation, do we see the resolution anywhere in the near future?
I think compensation and criminal are somewhat tied, and I'll address it that there is possible for resolution if there is a sustained focus on it by the appropriate judicial forums and the appropriate administrations to bring these cases to light. For instance, the Union Carbide case was reinstated by the judgment of the Honorable Supreme Court in 1991, in which Union Carbide has been an absconder. Actually, part of the money that was seized, the company that was seized and then sold to Eveready, was basically used to set up this hospital as a proclaimed absconder. Now, Dow merged with Union Carbide in 2000.
Several changes.
Yes, but that summons to Dow has been pending in a stay since 2006 in the Madhya Pradesh High Court.
So till the time they don't join, nothing can happen.
Now, when they join, and if there is a judgment, because there is, we believe, not just prima facie, but strong indications of the guilt for 304 Part 2 of the corporation, that will result, because you cannot put a corporation jail in money judgment, a fine, which can then be used to compensate the victim. That is one. So the criminal part, in addition to what will also result in compensation for the victims for the toxic gas. Now, in addition to the toxic waste, that issue has never been settled with regard to compensation. So all those claims are open against Union Carbide and Dow, against the Madhya Pradesh government.
How many more years do you see this entire fight going on?
I'm afraid that history is not kind on this issue to the players. And if history is any guide, then I'll be doing it for the rest of my life at least, fighting for this.
So which essentially means another 55 years.
So yes. We have said that setting
roughly,
up...
I get it.
Setting up special courts. You know, we have said that these cases can be...
so sustained judicial focus.
There's no resolution yet. There's no direction yet.
By setting up a special court, these can be resolved. These issues can be resolved.
Ma'am, I'll get you on the health aspect. Do you actually see anything happening as far as, especially after the new ruling, that the entire thing will be overlooked, the health aspect, the hospitals will be overlooked by the Madhya Pradesh High Court, and the trust hospital will go into the hands of the Ministry of Health? On that aspect, do you see any, this change actually helping the victims?
The fact that from chemicals and fertilizers and atomic energy, it moves to health. It's a shift. At least you start thinking of health and the and the responsibility. See, I just want to add one or two things. The toxins in the soil, in the water, they are mercury, arsenic, cadmium, and they are not chota-mota chemicals. These are the ones that are going to cause damage, DNA in this generation after generation. And that is not been taken into account when you've been talking about the question of compensation earlier. So, who is going to be fixing up
the compensation, assessing the compensation? Because
when you say ki quash kiya, not only the 89 ka quash kiya pehle ka, but it was also future. How can any government talk about the future when you're stopping the ICMR ka long-term thing in 10 years? You're not even looking at the magnitude and the depth of the health
contamination.
No, the health impact. I'm looking at the people. Don't look at the soil. Look at what it is doing to the. Had rich people got the gas,
it would have been resolved much earlier.
It would have been resolved earlier. Had health been at the center of the, with the responsibility, then whatever you
are actually saying there is lack of will on part of the state government and the centre.
Yeah, because as I mentioned earlier, when you're saying what are the protocols, what is the healthcare, are you going to give more steroids, more antibiotic? When you say healthcare, what is it? When you did not give sodium thiosulfate when it was needed, and multi-organ, multi-system involvement is there, and you are not even recognizing as the health impact of all this toxins, gas and food. So, when you are not acknowledging that, what are you going to be treating?
Again, ma'am, it's time for us to head into a break. When we come back, we will show you an interview with Mr. Sanjay Parekh, advocate in the Supreme Court. Welcome back. My colleague Subina Roy spoke to advocate in the Supreme Court, Mr. Sanjay Parekh, and tried to get his perspective.
After the Bhopal gas tragedy, different committees were set up. What was the reason behind setting up two different committees like the advisory committee and the monitoring committee?
In the incident which had taken place, nearly 22,000 people they had died, and more than 10 lakhs they were affected by the gas. Now, there were simple injuries, grievous injuries, etc. In order to really do a proper kind of study and also proper treatment, two committees were appointed by the Supreme Court. One was a monitoring committee, the other one was an advisory committee. These committees were periodically submitting their reports before the Supreme Court. There was an order which was passed that there should be smart card and also health booklets which will be given to the individual patients, but that was not implemented by the state government. And it is now because of the direction which has been given by the Supreme Court that there is a direction that there should be smart card and health booklets which will be issued to the individual patients.
Why did the Supreme Court order to dissolve the Bhopal Memorial Trust?
See, initially the Bhopal Memorial Trust was created for the purpose of giving treatment to the Bhopal gas victims. But then it was not functioning properly. Initially it was for 8 years, and when the court found that it is not discharging its duties or obligations properly, they decided to dissolve the trust.
Bhopal gas tragedy will now be handled by the High Court. So what will be the implications?
There are two directions which have been given. One is that the waste which is hazardous waste which is lying near the factory, that should be removed within a period of 6 months. The other one is that all environmental problems which are there, they will be now tackled by the National Green Tribunal. But the direction is not confined only to the Bhopal case. It's a general direction which has been given. So because of that direction, all cases which are pending before different high courts, before different authorities, and even the civil courts, they will all be transferred to the NGT, National Green Tribunal. And tribunal will have to now deal with those cases.
It's due to a blanket ban by the Supreme Court that no litigation has been filed against the Union Carbide after 1989. Now, that is limited just to the civil matters, because later on the criminal matters were opened for litigation. I'll get Mr. Jayaprakash in. What is the aspect of the judgment that you were pointing out?
No, the present judgment focuses on restarting medical research, which was stopped by the, which was abandoned by the ICMR in 1994, which is a positive step. Secondly, the court has directed the state government and the ICMR to ensure that health booklets are issued to each gas victims with complete medical history of his or her, which is very. Then the third aspect is to ensure that there's a proper protocol of treating gas victims, you know, because right now all kinds of medicines are given to gas victims for all kinds of diseases, and victims go from one hospital to another and consume all kinds of drugs, etc. You know, which is fourthly, the court has directed there must be proper environmental remediation, for which what I am saying is that there must be a proper assessment of the extent of damage.
Right. Yeah. And I'll get Mr. Avi, what is it that you're talking in 1989 and also relating and linking it to the other aspect and the linking it to the present judgment and the impact of it?
It's very important to remember that the role of the Union of India in 1989 was based on the 1985 Bhopal Act, which made it the parens patriae, which is a legal term, meaning I am your legal representative and have a fiduciary legal responsibility to take care of all the victims.
Yeah.
So on that basis, on their behalf, they entered into a settlement with Union Carbide and took on the responsibility to care, protect the rights and the relief of the victims. The 9th August 2012 judgment is an indictment. It basically says they have even failed in their most basic role, which is to give medical relief based on, with the money that was taken from the compensation and other sources, to give medical relief to the victims, that they have not even provided the most basic level of relief, let alone compensation, let alone monetary compensation. And in that, the government has not only failed in its role as a government, as the Union of India, but has also failed in its role as a parens patriae, which it took upon itself based on the 1985 Act, and which is the basis of the 89 settlement.
And ma'am, on the point of the health impact on the children, the new generation, and how do you resolve that?
No, I think the basic needs of the people who have suffered, it should be for all. But at least the question of drinking water, you know, adequate nutritive food, because all their money is going in running from in medical care, irrational, exploitative, by the way. The children that are being born congenitally malformed because of what's called the teratogenic effect of these hazardous chemicals, that when they're in the womb, the mother is exposed. And there's going to be more and more, and the intergenerational. The responsibility of this, the care and the rehabilitation of this is also part of this package, because just giving the health cards and just giving few medicines is not basically the answer. And for this, adequate budget has to come, and I think the government of India, union level, cannot wash its hand. It cannot be left, Madhya Pradesh will do, and they said, oh, we don't have money, etc. And Planning Commission should take responsibility to allocate enough, because with the universal health care with 1.5% as the health budget, they'll say, no, we cannot even do, ICMR cannot do long-term research, so-and-so cannot do this, because they say, oh, health doesn't have enough money. So how much money budget is allocated to make sure that at least these people get justice?
Better health.
Yeah.
Thank you, ma'am. Thank you, sir.
The biggest challenge we are facing is that to ensure that this judgment is actually implemented by the state government and the ICMR.
Thank you, ma'am. Thank you, sir, for joining us on this discussion. It's time for us to end the show. You can email your suggestions and comments to law.rstv@gmail.com. You can also watch our shows on the YouTube. We'll be back with a new issue and a new episode. Keep watching Rajya Sabha TV.